It's another cruise video. Someone wants to know whether judges can practice law on the side to earn extra money while being a judge. I'll tell you about that in just a minute. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So someone wants to know whether the judge can practice law on the side to earn extra income, even though they're a judge. The answer to that is in most cases no, but there are a few exceptions. Just like the federal system has magistrate judges and bankruptcy judges who are not Article 3 federal judges, state court systems have judges that are not real judges. In Missouri, for example, municipal judges are appointed by the mayors of their cities. Now, these are plum jobs that lawyers get, and they get paid a salary by the city to do this job. I would also point out that in most cases, the city prosecutor, gets the same deal. They get this plum job and they get paid by the city essentially to handle traffic tickets and zoning ordinance problems and that sort of thing. Now, the salary requires that they come into court at least once a week, hold court, and then preside over traffic tickets and these municipal offenses and zoning problems and the like. When I was in law school, I clerked for a little firm called Wyan, Klippel, and Mannion. They were a great bunch of guys, and I got a lot of really good experience between my first and second year of law school. The oldest member of the firm was Judge Wyan. He was a municipal judge in the city of Overland, Missouri, which coincidentally is where I lived when I lived in St. Louis. As part of his duties, he presided over the municipal court in Overland, and as a result, whenever a case came into that office that dealt in any way with the city of Overland, somebody stumbled on a sidewalk and hurt their leg or whatever, he had to be walled off from it. We couldn't talk to him about it. Nobody could talk to him about it, and no one could mention the case to him. But he could still go on writing wills, drafting contracts, and handling traffic tickets in other jurisdictions. The latter was especially important because when he went to a different city and sat down with the prosecutor there and said, "How about amending this 35 miles an hour over the speed limit charge to defective equipment?" The prosecutor, as I mentioned, also an appointee, understood that if he ever got a ticket or any of his clients ever got a ticket in the city of Overland, they would likely get the same consideration in the city of Overland. So it was one hand washing another. Was that strictly an ethical breach? Well, I guess if anybody had known about it, it might have been. But municipal judges were allowed to practice law in addition to being a municipal judge. Now, they had to subscribe to all the other canons of judicial ethics. They couldn't be unfair. They couldn't, take bribes or anything like that. But the workload for a municipal judge was light. In other words, they didn't have to have court every day, just once a week. And so, since they couldn't be a full-time employee, they had to make money somewhere else, and they were allowed to practice law, just with the ethical constraint that if it came in anything that came in about the city, they couldn't handle that. Now, state court judges and circuit court judges, associate circuit court judges, appellate court judges, they are all held to the canons of judicial conduct. So let's look at the canons as they're adopted by the state of Alabama, and in particular, Canon 5. It says that judges have to regulate their lives outside the courtroom to avoid conflicts with their duties. Let's take a look at that canon right now. As you can see, it says a judge should regulate his extrajudicial activities to minimize the risk of conflict with his official duties. It says he can engage in avocational activities, and he should not serve if it's likely that his organization will be engaged in proceedings that would ordinarily come before him. It's desirable the judge not solicit funds for educational or religious purposes, and the judge should refrain from financial and business dealings that tend to reflect adversely on his impartiality. In addition to that, information acquired by a judge in his judicial capacity should not be used or disclosed by him in financial dealings or for any purpose not related to his judicial office. And then finally, part of F there, he cannot practice law. A judge should not practice law. So, why do you have to regulate your activities outside the courtroom? Well, because when you're a judge, even your off the clock behavior can affect whether people trust your judgment. Canon 5 basically says a lawyer should regulate his extrajudicial activities to minimize the risk of conflict with his judicial duties, and that means hobbies, charity work, finances, side jobs, and even whether they can be a trustee in a family member's will. It is really about preserving public confidence that the judge is fair, impartial, and focused on his or her role. Now, sometimes judges have avocational activities as well. Chapter 5 starts by recognizing that judges are not Buddhist monks. They can write, they can lecture, they can teach, they can play golf, they can paint, and they can coach Little League. But here's the catch: the activities can't interfere with their judicial duties or diminish the dignity of their office. So, for example, a female judge could not decide on her off time to go dance at a strip club, for example. That would be calling her office into disrepute. And it's fine for a judge to give a lecture on Civil War history, but it's not okay if they start making jokes in public about criminal defendants or verdicts that they've handed down. The goal is that judges should stay connected to the community, but never at the expense of appearing biased, distracted, or unprofessional. Gosh, I hope there's a judge in Massachusetts who's paying attention to this. But at any rate, civic and charitable work is allowed, but again, you have to be careful. Judges can serve on boards of charities, religious organizations, or civic clubs as long as those groups don't regularly go to court or lobby for political gain. If they do, then the judge has to step off of that board. There are three big limitations on serving on boards. No serving on boards that are likely to come before that judge's court. So, for example, if you are on the board of trustees for the, uh, let's say, the public defender system, well, those people are going to come before your court. You could not possibly serve on that board or continue to serve on that board if you were appointed to be a judge. However, if you were on the board of, say, the Girl Scouts, it's pretty unlikely that the Girl Scouts are going to get into a tiff such they're going to come before you. But of course, if they did, you would have to recuse. The judge also can't be involved in fundraising for any civic or nonprofit entity. You can't have a poster up in your city that says Judge Bill says to give to the Boy Scouts, because that puts the judicial stamp of approval on that organization. And that's just not something that's allowed by the canons of judicial ethics. And the judge can't give investment advice even if the judge is on the board. Why? Well, because even a whiff of undue influence or favoritism can call a judge's impartiality into question. And then they also have to keep it clean when it comes to financial activities. Judges are allowed to own property, run a business, and manage investments, but they can't use their position to gain an unfair advantage. For example, you have XYZ Corporation that has been sued for product liability. And you know that the case is very weak, unlikely to succeed. And in fact, you as judge are thinking of granting a motion for summary judgment against the plaintiff. You can't pick up the phone and call your wife and say, "Hey, Gertrude, guess what? I want you to go out and buy 10,000 shares of XYZ Corporation. I have a feeling their stock is going to take off." And then grant that order for summary judgment. You can't use confidential court information to help them yourself or anybody else. So if a judge learns that a company is about to be sued, they can't sell he can't sell any stock that he has, and that would be before the news breaks, that would be using inside information, which is usually a federal crime. That's why in some states, judges, and even in states where this isn't mandated, smart judges do this. They set up what's called a blind trust. They go to a lawyer that they trust and they say, Jim Bob, do me a favor, set me up a blind trust. Here are the stocks I own. I'm going to convey them into the blind trust. You manage those investments for me and never tell me anything about it until I get off the bench. And that works. That way, the judge can't possibly be influenced by something, court ruling, if he doesn't know how it would affect the investments that are being managed by somebody else. Judges are also expected to avoid financial entanglements that would cause them to disqualify themselves from hearing cases. So that's pretty important too. You can't own stock in companies that are frequently litigated, like Ford Motor Company, GM, that sort of thing. Again, because those companies get sued quite a bit. And also you couldn't own stock in an insurance company because again, insurance companies tend to have to do business with the courts quite a lot. And then a judge can't do fiduciary duties generally. They shouldn't serve as an executor, trustee, or guardian unless it's for a close family member, and even then, only if it doesn't interfere with his court duties. And even in those roles, they still have to follow the same ethical rules they would in their personal finances. So, for example, while they're administering the estate of Uncle Billy, and they realize Uncle Billy has, 50 shares of uh, XYZ stock, and they know that XYZ is about to get hit with a multi-million-dollar lawsuit, he can't decide as the trustee to go ahead and sell that stock because he knows what's coming. Again, that's insider trading. Being a fiduciary gives somebody control over other people's money or decisions, and it can lead to conflicts of interest, especially if disputes arise. So, if the judge is the trustee or the administrator of the estate of Uncle Billy, and two or three people have claims against the estate, that could wind up in his courtroom. So, in that situation, he would have to recuse from that, and he would probably have to resign as the administrator. And generally speaking, a judge isn't going to be an administrator unless there's absolutely nobody else to do that job. That's just the smart way to behave. Canon 5 of the judicial ethics also has bans on certain things. Judges can't act as arbitrators or mediators because they're supposed to resolve real court cases, not moonlight in private disputes. Now, retired judges are often sought out as arbitrators or mediators because they have a wealth of experience and they are allowed to use their expertise in that regard to act as a mediator or an arbitrator. But sitting judges cannot. Judges can't practice law. Once you're on the bench, your lawyer days are over until you come off the bench. Now, I worked for a judge who was a judge at the time. I did a clerkship with him. And then when he came off the bench, he hired me to work with him on another project. And when they come off the bench, they can do pretty much anything other than argue in front of the court that they left for a period. I believe it's of 1 year, it might be 2 years, but they have a timeout period where they can't appear in the court that they were a judge of. And again, they can't do that because it just looks kind of skeevy. And judges shouldn't serve on government committees unless it's about improving the law or the justice system. But judges can represent their community at public events and ceremonies and historical things, and they do get to perform weddings. That's kind of a neat thing that my old boss used to love to do, is to go perform weddings for people. Now, why these rules matter? Canon 5 exists to protect something priceless, public trust in the judiciary. Of course, sometimes judges work very hard to erode public trust in the judiciary. I'm not thinking of anybody in particular here. Anyway, if a judge appears to have a hidden agenda, a financial stake, or divided loyalty, or is very, very biased in one direction, then justice suffers, even if no actual wrongdoing occurs. These rules don't exist to limit judges, but to remind them that their role in society is unique. They are the guardians of fairness, and that judge doesn't end when the court adjourns. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.